Thank you, Manny. And it's a real pleasure, genuine pleasure for San Angelo Live to have three sitting Texas Supreme Court justices in our studios this afternoon. And Manny, you won't believe what we're going to talk about, but here we go. First of all, I'll just introduce them. Sitting on the left is Justice Evan Young. He's at place 9. He's in the place 9 for the Supreme Court. And please understand, all these justices in Texas are elected by the people. So there's an election coming up in November. Remember their names and faces. They're all Republicans. So the place 9 justice is Evan Young. And then in the middle is a senior Texas Supreme Court justice, Deborah Lehrman. And all there on the other side, to your right, is place 5 Justice Rebecca Huddle. And like I said, all of these are all these fine men and women are Republicans, and they're up for re-election November 7th. And the first question, I guess, we always have to ask this is, for the normal, everyday guy, what the heck does this Texas Supreme Court, where does it sit in the whole, stack of courts? We hear about district courts, county court at laws, all that kind of. Where does the Supreme Court sit, and what kind of cases do you hear? Anyone can take the question.
The Supreme Court is our state's highest civil court, and so anything other than adult criminal conduct comes to our court. And the way you put that is interesting. Where do we sit? We sit in Austin, but we like to sit other places too. And one of the things that before the pandemic that we used to do, that the court would do before I joined it, was to go across this big, beautiful state and visit other communities and hold a day of hearings so that people in cities like San Angelo could watch the Supreme Court preside over some of the cases on our docket. We haven't been able to do that for a few years, and so I'm delighted to be here with my two colleagues to be able to come to San Angelo and some other places so that we can replicate the experience of seeing and interacting with and visiting with people across Texas and talking about where the Supreme Court sits, both figuratively and literally. And the answer is that hopefully nobody watching has ever had to come and have their case at the Supreme Court of Texas, but what we do is to decide the important civil cases that affect every aspect of every Texan's life. Family law matters, contract matters, employment matters, tax matters. Everything in the civil side of our docket comes to us, and our job is to try to make the law as clear and uniform and consistent across our state as we can.
I was going to follow up with that, and Justice Lehrman, maybe you can take the lead on this one. Since you're here in Tom Green County, I want to talk about a local issue, and kind of so mostly to illustrate to people here in the county how some decisions that our Texas Supreme Court makes impacts our county. Obviously, COVID impacted the entire nation, the entire world, but here locally, as far as our judicial justice system, COVID backed up our entire court system. And one of the not the complaints, but one of the reasons was we had like the Office of Court Administration, or OCA, which the Supreme Court has a lot to say in how they administer the rules. They came out with the COVID social distancing policies and things like that. And what happened was we couldn't sit large juries. So when we had a murder trial, for example, we had no room, no facility in San Angelo, Texas, where we could seat a jury large enough, or a jury pool large enough to be able to do the jury selection in order to have the trial. So what we had was we had a lot of hardened criminals, more and more hardened criminals stacking up in our jail. Our jail has a population or a limit of about 551 people. We had, sometimes during the COVID, we had over 600 in there. So how did COVID impact statewide? You saw the picture from the top, and how did that relate to what we saw here in Tom Green County? Justice Lehrman.
It was a very challenging time, as we all know. The last 2 years have been devastating to the citizens of this great state, and it was very challenging for the court because here we were faced with this reality that we were all pretty much quarantined, and that meant that none of us could go anywhere, yet justice has to proceed. And in those cases that you're talking about where you have people who are accused of crimes, and their liberty is at stake on the one hand, and on the other hand, many of them are accused of very, very serious, dangerous conduct. And so what do you do? through the Office of Court Administration. Our Chief Justice worked very, very closely with that office and came up with this idea of Zoom hearings, and that's what we instituted. At our court, we actually did not miss a beat. We had our very next oral argument that was immediately after the entire quarantine started was conducted by Zoom. And for an appellate court, that works pretty well. I think we like it better to be there in person, but because we don't have exhibits, we don't have those types of issues where a judge's role on the appellate court is not to have eye-to-eye contact with the witnesses to be able to judge credibility and those kinds of things. We're looking at the law and at the record, basically. And so it worked very well for our courts. Some of the district courts had a little bit more issue with that, and I think that's really what you're getting at.
Right.
And that was really a big issue in terms of our criminal courts. So now we have a backlog. We have a lot of visiting judges throughout the state who are really, really stepping up and helping for us to get rid of that backlog, because it's something that certainly has to be dealt with sooner rather than later. But it was certainly an issue. Now we're looking at how much we've learned in terms of virtual hearings as far as what we should keep and what we should not keep. And there were some good things that we learned from the pandemic in terms of virtual hearings. Right. We have a committee who's looking into that, who will report back to us through our advisory board, and we'll make some more long-term decisions. But those questions are very, very challenging. They're not easy answers, but it's important, and we are looking at it seriously.
Judge Hyde, I want to follow up with that question. One of the things that happened is the county got saved by Zoom, in that we used to have the jail right across the street from the old historic courthouse, and once or twice a month we'd run all the people that needed criminal pretrials across from the jail into the courtroom, and they'd have this mass hearing. To do that today would cost the county a fortune in transportation costs. We'd have to become basically a bus company to do that. So the Zoom calls for criminal pretrials is actually saving us money. Yet, I hear there's rumblings in Austin, primarily on the legislative side, that we might want to do away with Zoom calls for criminal hearings if the judge makes a decision about that person. I mean, it could be a pretrial where they make a decision about, I guess, a plea deal or whatever. And so therefore they would do away with the Zoom calls altogether, and that's going to end up costing Tom Green County a fortune. Where are your thoughts on, as far as what types of hearings you could have on Zoom, and just talk about the legality and the rights of the citizens when we're using Zoom?
Well, thanks. So the example you gave is a great, very concrete example that anyone living in Tom Green County can physically see, right? People walking across the street. The challenge in figuring out what of Zoom to keep for the long term into perpetuity, and what to do away with now that we've come out of the pandemic, we've developed tools for managing it, is to find the right balance. There are lots of ways in which Zoom has been an incredible asset. It has allowed, the example you just gave is a great one. It has allowed these pretrial hearings to happen at huge cost efficiency. That efficiency we've seen in many other places of the law. Take family cases, for example, where you have families that need to come to court, where children may be needed to be pulled out of school to drive 2 or 3 hours to the courthouse to just have a formalistic 10-minute exchange with a judge. Well, it doesn't make sense to put that burden on the family or on the child taking them out of school, having the parents take a whole day off. I mean, that is a quintessential example of where Zoom makes sense, and we should keep it. There is the other end of the extreme, though, where Zoom cannot replace everything that happens in a courtroom, and it isn't appropriate, in my view, for every kind of activity that goes on in a courtroom. If you have a criminal trial, for example, we don't have adult criminal jurisdiction, and so this is not where we work, but that's not an exercise that should be happening on Zoom absent agreement. There are constitutional issues the right to confrontation. There are lots of constitutional issues at stake, and so I don't view Zoom as a replacement for the old-fashioned courthouse, but I do think there are some savings to be gotten. The trick is in figuring out and writing a new rule that delineates where we should take advantage of those efficiencies. But it can't be everywhere.
All right, that is a big issue that people are thinking about. I'm going to go now to more of a national issue, and I don't know if y'all can talk about this because it involves Roe versus Wade, and that's a big hot button issue. But we had the leak in the Supreme Court of Justice Alito's opinion, and it seems to me from reading the news that leak was probably done to persuade the U.S. Supreme Court to rule one way or the other. Let's talk about how activists sometimes believe that the ends justify the means, and they're tearing up our institutions like that. And how do you view that, and how would you combat against that? And I guess we can start with Justice Young.
Well, I'm glad to answer that and talk about this leak at the Supreme Court. I was a law clerk for Justice Scalia at the U.S. Supreme Court many years ago. And Justice Scalia made as abundantly clear as possible that if we ever were to breach the court's deliberative process, not just by releasing an entire draft opinion, that's never really happened before, but even by talking to people about what the court was about to do, he would destroy us if he could. And he used that exact word. And we could tell he meant it, as he meant most everything he said. The reason is not so much that any particular case is one that shouldn't be scrutinized. Every case should be looked at by everyone. The work of the court belongs to the American people. The work of our court belongs to the people of Texas. But the people have chosen to have a government that has a judicial branch that is not supposed to be a political branch. And we have to be able to do our work with the deliberation that the judicial process requires. We have to be able to trust our staff and to trust each other. And the American people have to know that what's happening in the process from oral argument up until decision making is the work of judges trying to get the best answer they can by talking to each other about the law and exchanging ideas and improving the work product. If the links that bind the judges to each other and to their staffs is severed, and those bonds of trust are frayed, we wouldn't be able to do our work in the way that the American people and the people of Texas expect and deserve. And so I regard this leak as a serious threat to the independence of the judiciary and a threat to the non-politicization of the judiciary. And the fact that somebody might dislike a particular outcome in a particular case by no means justifies the attempt to destroy the institution, the way you put it, to tear apart the foundation of these important institutions that have been centuries in the making.
Now, obviously, the Alito leak was a big deal. Justice Lerman, you've been on the Texas Supreme Court for a long time. Has there ever been a situation where you felt threatened or pushed to decide a case one way or the other?
Well, certainly, just a central issue that we always deal with is to make sure that we put aside our own personal views in making our decisions and that we follow the law. And you hear that all of the time, but it's really true. And that takes introspection. It takes a person who's willing to really look within themselves and determine what their personal views are. We all have them. We're human beings. But we have to focus on what they are so that we can set them aside in making those decisions. As far as the court goes, I don't think the court has ever had but one breach over all these years, and it involved actually two clerks or several clerks who were having lunch at a restaurant, and it just so happens that at the table next to them were a group of lawyers who were involved in the case, and they overheard what the clerks were saying. So every year in orientation, we are very, very clear about telling our clerks how important it is that you not only, of course, don't do something intentional, because we don't want to have to destroy them, as Justice Scalia would, but we do definitely expect them to respect the process and make sure that they look around themselves, because just accidental leaks can be very, very difficult and very bad on the process. We depend on being able to be confidential. What we say, our deliberations are confidential, and if we don't continue that process, it really does affect the jurisprudence of the state of Texas.
I got one more question that's sort of related. You know, we're going into an election right now that's, I mean, it kind of smells like 2018 again. I mean, we have Beto on the ticket, and, you know, he brings out a lot of the left and the Democrats, and there's a lot of organizing behind that. And you're going into a general election with Beto on the ballot. You know, the Third Court of Appeals in Austin was overturned from Republican to Democrat on Beto's coattails. And so this year we have that same. It could happen if fire lights underneath the Beto campaign and he gets a lot of money. I interviewed every candidate on the third court, every Democrat that won, and one of the big things I would always say, because I'm a Republican, I would say, how's a Democrat going to interpret the law? Are you going to interpret the Constitution as an originalist? How do you view the law as, you know, as opposed to how, I say, Justice Bork would? Remember the Bork hearings back in the late 80s? And all of them said it's the law. It's all about the law. It's not being about being a Democrat. It's not being about a Republican. So Justice Huddle, a Republican versus a Democrat view of, I guess, the Constitution. And just we can start from the top and kind of work down. How different would that be having a Republican charge of making a decision versus having a Democrat in a judicial judge kind of thing?
Well, the irony of it is that it should be the very same, right? The work that we do, the substance of what we're doing, should not be political. And so every lawyer, every judge who's approaching a case, a decision, if they are actually following the law, ought to come to the same conclusion. And so that you know, the mantra you just said that you heard from candidates in the past is one that we hear all over the political spectrum, and everyone says it. And so you know, I'm going to follow the law. I won't legislate from the bench. You know, nearly every judicial candidate can be heard to say those very words. And so the question becomes for me, how do you know whether that will be true, or those are just words someone is spouting for the sake of trying to, you know, earn a few more votes? And that can be a difficult question. It can be it take energy to do, but in the case of many justices who have served before and have a body of work, I mean, that is one thing to do, is look at their record. What have they done in the past? Mm-hmm. And so that's, you know, one obvious approach to get at the question of, can I trust this person when they say, this is the kind of judge I'm going to be?
Can I answer that as well?
Sure, go for it.
You know, the concept of I will follow the law, I assume to be true. I assume that every judge who says that means it. I don't think anybody's probably lying to you. But the question is, well, how do you find out what the law is? What is the law to you? And if the law is what social consensus ought to make it, if it's what you think good policy is, if it's what you think the evolving standards of constitutional law might be, it's a very difficult question to answer, to say, well, I'm going to follow the law. Well, what is that? On the other hand, if your commitment is to understanding what the words of the Constitution, what the words of a statute meant at the time that they were enacted, that's essentially what originalism, what textualism, as Justice Scalia called it, what that is. It doesn't make it easy, as Justice Huddle says. Sometimes a statute can be dozens and dozens of pages long. Contracts, you can have many contracts all interlocking, and they might have been written over decades. You could have the same thing with any legal document in any branch of the law. It can be very hard work. But if we're committed to the idea that the words used in legal enactments have meaning, that meaning is findable, and then it can be applied by judges, then judges are doing a very different job than those who might think that judges are there to rule society and find out what is good and true and how people should live their lives. I can only answer for myself. I can't answer for other Republicans or for Democrats, but the way that I understand the judicial function to be different from the legislative or executive branch function is that my authority extends only to doing the lawyerly task of saying, here's what the Constitution meant when it was enacted, and so it means the same thing today. Now let's apply it to whatever new circumstances might have arisen. And that's the opposite of living constitutionalism or purposivism or any of the other isms isms that are out there that take judges away from interpreting the law as it was written and move it more towards making the law, remaking the law in their own image.
Justice Lerman, I want to follow up with that. Just to give you a historical context, I mean, you've been on the court for a long time. Have you been on the court where it kind of leaned a little bit more to the left than the right? And, you know, just kind of tell me what the feeling or, you know, how that was working out for you.
I haven't really seen a difference in that. The entire time that I've been on the court, I believe that all of the justices are really dedicated to that principle of really trying to make sure that we are not deciding these cases in accordance with our own personal views. And I can tell you that every one of us has made decisions that if those decisions were based upon our own personal views, they would have not come out the way they did or in accordance with our particular opinion, because that's just not what it's about. We really work so hard to look at whatever it is, whether it be a statute, whether it be a contract, whether it be the Texas Constitution, the United States Constitution, look very, very hard at those documents to make sure that we're following those things. And so many of our cases involve statutory interpretation. A huge number of cases involve that. That's not always easy, as my colleagues have said, to figure out exactly what those statutes mean, because they're very long and sometimes they're very confusing, quite frankly. But we do the best we can to really determine what the law is and put our own personal views aside. And I've really seen that the entire time I've been on the court.
Well, thank all three of you for coming by the San Angelo Live Studios. This is a real honor for our small little news organization. Once again, on your left is Justin's place, help me out here.
Place 9.
Place 9, Justice Evan Young, and then Senior Justice Deborah Lerman. She's place 3. And then to your right is place 5, Justice Rebecca Huddle. And it's been a real honor to be able to interview you, and I really appreciate your insight.
Real pleasure.
Thank you so much,
Joe,
for having
thanks so
us.
much for having us.
Manny, back to you.